My mother-in-law arrived with 3 lawyers to take my late husband's house. She had no idea what I did before I became his wife. She arrived with 3 high-priced attorneys, convinced her wealth and influence guaranteed victory. I walked in with a single, unassuming folder. The courtroom buzzed with expectation, but no one, especially not her, bothered to ask what I truly brought to the fight. My former mother-in-law, Beatrice Sterling, cornered me against the cold marble wall of the courthouse precisely at 8:47 in the morning. I remember the exact time because precision has been a habit of mine for 26 years. And it mattered, because the courtroom doors wouldn't open until 9, leaving 11 minutes in that silent corridor where Beatrice believed privacy was on her side. Her diamond rings dug sharply into my shoulder. Her face, a mere 6 inches from mine, was a mask of practiced fury, the kind perfected by someone who'd spent 6 decades getting her way by making the alternative utterly unbearable. She wore an Armani suit that easily cost more than most people's monthly rent. "You are nothing but a gold-digging parasite," she hissed, her voice low and venomous. Arthur was out of his mind on chemotherapy when he signed that deed. Today, I'm taking it back. I met her gaze. I didn't flinch. I didn't blink. Instead, a familiar weight settled deep in my chest, a quiet click, like a safety engaging. I recognized it instantly, an old and trusted companion I hadn't needed in 5 years. It was the specific, icy calm I'd first discovered in a Stuttgart courtroom when I was 31, facing a defense counsel with twice my experience and a client tied to 3 governments. But I had the evidence, the law, and the patience to wait for the perfect moment. I still possessed all 3. Her lead attorney, Mr. Albright, materialized beside her. He'd introduced himself earlier with the self-assuredness of a man who's never lost a civil case, attributing it to character rather than good fortune. His smile was designed to convey that he found my presence beneath his consideration. "Mrs. Vance," he began smoothly, his voice radiating the practiced warmth of someone who charges $800 an hour and needs you to believe it's justified. "You're unrepresented. You lack the financial resources or the lineage to contest the Sterling family's claim. Sign the settlement agreement, walk away with your dignity, and we can all be home by lunchtime." My daughter, Chloe, stood directly behind me, her hand resting on my arm. Her eyes were red-rimmed, a testament to 2 weeks of sleepless nights. "Mom," she whispered, her voice barely audible, "please, it's not too late to settle. We don't have to do this." Just then, the courtroom doors swung open. I looked at Beatrice, then at Mr. Albright, and finally at Chloe. "Let's go inside," I said. "Before I reveal what unfolded in that courtroom, I need to tell you who I truly am." Because Beatrice Sterling had never bothered to ask that question. In 9 years as my mother-in-law, she'd never formed a complete picture of the woman her son had married. And her failure to inquire was the sole reason that morning unfolded exactly as it did. My name is Eleanor Vance, and I am 61 years old. Until my retirement 5 years ago, I served as a colonel in the United States Army Judge Advocate General's Corps, the JAG Corps, the military's legal branch. For 26 years, I prosecuted court-martial cases, advised commanders on legal matters in the field, and spent 8 of those years in the European theater, operating out of a regional command in Stuttgart, Germany. I have tried cases in 4 countries. I have prosecuted war crimes, financial fraud, conduct unbecoming, and other matters I am not at liberty to discuss publicly. I have cross-examined witnesses trained to withstand interrogation, and I have argued before judges who had seen everything and were impressed by nothing. I retired at 56, returning home to the lake house Arthur and I had bought together. For 5 years, I was Arthur's wife and Chloe's mother. I cooked dinners, read novels on the porch, and allowed the part of my brain that thrived in courtrooms to finally quiet. Arthur fell ill in the spring of what would be his final year. Pancreatic cancer, diagnosed late, managed aggressively, but ultimately, unsuccessfully. He passed away 11 months after his diagnosis. He was 64. What he left behind, legally and deliberately, was the lake house, placed solely in my name. That decision, documented, notarized, and executed 8 months before his death, at a time when Arthur Vance was fully lucid and medicated only with a mild anti-nausea prescription, was not the act of a man manipulated by his wife. It was the decision of a man who, over 64 years, had witnessed his mother's relationship with money and had formed a clear-eyed understanding of what she would do once he was gone. He was right about everything, as he usually was. I must also tell you about Beatrice Sterling before we delve into the courtroom proceedings, because context is everything. Without it, Beatrice is merely a villain, and villains without context are dull. Beatrice Sterling, she never adopted her husband's surname, a point of pride she maintained with the consistency of a personal manifesto, was born into old money and mothered by older grievances. She had been beautiful in her youth, formidable in middle age, and by her late 60s, her energy had converged into a singular, focused channel, the protection and expansion of what she considered the Sterling family estate. The lake house was the original Sterling family property. Beatrice's grandfather had built it in the 1940s. It passed through 2 generations and eventually reached Arthur, the last of the direct Sterling line. Arthur had bought out his aunt's shares in the mid-1990s, making himself, and after our marriage, us, the sole owners. Beatrice had never accepted this. She had accepted it legally, there was nothing she could do about it from a legal standpoint. But she harbored the specific, sustained resentment of a woman who believed family property belonged to the family she defined as family, which decidedly did not include me. From the very first dinner in 1994, when Arthur brought me home, she looked at me like a competitor, not a person. I was too old, in her estimation, when Arthur married me. I was too independent. I had a career she found vaguely threatening, though she could never quite articulate why. I didn't need Arthur's money, which was perhaps her greatest grievance. A woman who doesn't need money is a woman whose attachment to a man must be interpreted differently, and interpreting it differently was something Beatrice refused to do. She called me a gold digger at our first family Christmas, a comment delivered to Arthur's aunt that I wasn't supposed to overhear, but did. I didn't respond. I filed it away. Filing things away is what I do. Over 9 years of marriage, 11 months of illness, and the specific, accumulating weight of watching Arthur die by degrees, I filed away a great many things about Beatrice Sterling, the phone calls at hours designed to exhaust him, the unannounced visits that depleted Arthur's energy for days afterward, the documents she sent through her own attorney in Arthur's final 2 months, attempting to transfer the lake house into a Sterling family trust before his death, which Arthur flatly refused. Using terms I hadn't heard from him in years, terms that belonged to the man he'd been before cancer took so much from him. I had a recording of one of those conversations. Arthur had made it himself on his phone, because as Beatrice Sterling's son, he understood better than anyone that documentation was the only thing she respected. He handed me the phone. "Keep this," he'd said, "just in case." He knew. The warning signs had their own distinct chronology, which I want to outline, because the lawsuit didn't appear out of nowhere. The first serious red flag emerged 6 weeks after Arthur's diagnosis, when Beatrice arrived at the house, unannounced as always, with a set of documents she described as estate planning paperwork. She placed them on the kitchen table while Arthur was resting and suggested I encourage him to sign them. I examined them. They were a deed transfer, pre-executed, moving the lake house from joint ownership into the Sterling family trust. Beatrice was named as the trustee. "Arthur hasn't seen these," I stated. "He'll see them when he signs them," Beatrice replied. "This is family business." I picked up the documents and handed them back to her. "Get out of my house," I said. She left. She returned twice more in the following month, each time with a variation of the same pressure, each time with a slightly different framing: Arthur's legacy, the family's heritage, what his grandfather would have wanted. And each time, I declined, and she left angrier than she'd arrived. The second flag appeared in month 4 of Arthur's illness, when Beatrice's attorney, a different one from Mr. Albright, a local one, sent Arthur a formal letter outlining the Sterling family's historic interest in the property and suggesting that, given Arthur's health, a voluntary transfer would prevent future legal complications. I read the letter to Arthur in the bedroom. He asked for his phone. He made the recording that afternoon. The third flag was the settlement offer that arrived 2 weeks after Arthur's death, 4 days before the notice of suit. It came from Mr. Albright's firm. The offered sum was designed to appear generous, yet it was only 30% of the property's assessed value, coupled with release language crafted to waive not just the property claim but any future legal action related to the estate. I spent 45 minutes scrutinizing the settlement documents. I found 7 instances of language that were either ambiguously worded by accident or, more likely, by design. My experience with legal documents tells me that ambiguity in settlement agreements is almost never accidental. I declined the settlement. Mr. Albright's office called the following morning. I let it go to voicemail. "Lest," he said in the careful tone of a man attempting to sound helpful while delivering a veiled threat, they were prepared to proceed to court if necessary. The Sterling family's resources were considerable. Unrepresented parties in contested estate cases rarely prevailed against experienced counsel. He hoped I would reconsider before the hearing date. I noted the time of the call and the specific language he used. Then I went to Arthur's study, sat at his desk, opened the manila folder I'd been assembling for 6 weeks, and reviewed it one final time. It was ready. I was ready. I drove to the courthouse alone on the morning of the hearing. Chloe had offered to come, and I'd said yes, not because I needed her, but because I knew she needed to see how it ended. My daughter had spent 11 months watching her father die and 2 weeks watching the woman who claimed to have loved him try to strip away the last thing he'd left behind. She needed to witness the resolution. Beatrice's team had already occupied the plaintiff's table with the territorial efficiency of those who arrive early to a negotiation to signal their victory. 3 attorneys in expensive suits, Mr. Albright at the center, flanked by 2 associates like an organizational chart brought to life. They were surrounded by stacks of embossed folders, color-coded exhibits, and the tangible weight of resources spent. I sat at the defense table with my single manila folder. "One folder," Chloe whispered from the gallery. "Mom, they're going to crush you." "Watch," I replied. The bailiff called the room to order. Judge Davies entered. I want to describe Judge Davies accurately, because he was important. He was in his late 60s, with the compact, economical posture of a man who had spent time in environments where economy of movement was a necessity rather than a pose. He possessed a no-nonsense scowl that wasn't unfriendly, just profoundly honest, the face of someone with no patience for performance but considerable patience for substance. He had served as a military reservist in Germany for 3 years in the 1990s, a detail I'd known for 6 weeks, having researched judges the way I research everything, thoroughly and without shortcuts. He took the bench. His eyes swept across the room in the practiced manner of a judge assessing the space before proceedings begin. They passed over Mr. Albright's team, registered the abundant resources, noted the meticulous organization. Then they moved to me. They stopped. He looked at my face, then my posture, then my face again. His own posture shifted, perhaps a centimeter, becoming more upright. It was the subtle adjustment of someone who recognized something and was responding to it without any hint of drama. "Good morning, Colonel," Judge Davies said. The words landed with the clean, definitive impact of something dropped on a hard floor, impossible to unhear. Every head in the room swiveled to face me. Mr. Albright's pen slipped from his hand, striking the plaintiff's table and rolling towards the edge, and no one moved to retrieve it. Beatrice's smile, the tight, satisfied expression she'd worn since entering the room, the smile of a woman who had already calculated the outcome and was savoring the preamble, collapsed instantly into something that was not a smile at all. "Colonel," she hissed at Mr. Albright. Her whisper wasn't as quiet as she intended. Courtroom acoustics are unkind to secrets. What is he talking about? She's a housewife. Good morning, Your Honor, I responded, though I'd been retired from the JAG for 5 years. Judge Davies nodded once, with the specific warmth of someone acknowledging a colleague rather than performing a courtesy. Army Judge Advocate General's Corps, he stated for the room, his eyes still on me. Colonel Vance was one of the most formidable military prosecutors in the European theater. He then shifted his gaze to Mr. Albright. The quality of his expression changed, like a weather system, gradual at first, then unmistakable. You might want to buckle up, counselor. Mr. Albright had turned the color of old paper. He was looking at me with the expression of someone who has fundamentally misunderstood a situation and is only now beginning to gauge the vast distance between where they thought they were and where they actually stood. It was a significant distance. Mr. Albright recovered faster than I expected, for which I give him credit. He opened with the capacity argument. It's the strongest argument when challenging a deed transfer, and he had clearly prepared it meticulously. Arthur Vance, he argued, had been on high-dose pain management in his final months. The deed had been executed and filed during that period. The combination of terminal illness and significant medication, Mr. Albright contended, raised serious questions about Arthur's testamentary capacity at the time of the transfer. On its face, it was a reasonable argument. Your Honor, Mr. Albright said, his composure largely restored, his voice back to its practice register. Mr. Vance was on morphine at documented therapeutic levels in the final months of his life. Medical records, Plaintiff's Exhibit C, confirm a prescription of 40 milligrams daily as of the date the disputed deed was filed. We submit that a man in that condition lacks the legal capacity to make sound decisions about real property worth. Defense Exhibit A, I interjected. I opened my folder. The room fell silent with that specific quality of stillness that descends when something has been said that fundamentally alters the discussion. I placed the document on the bench, a certified copy for the judge, and a second certified copy for Mr. Albright, producing them simultaneously with the efficiency of someone who has performed this action many times before. A notarized letter of intent, signed by Arthur Vance 8 months before his death, I stated, 12 months before the deed transfer, at a time when Arthur's medication was limited to a low-dose anti-nausea prescription and a mild analgesic. I paused. In this letter, Arthur explicitly states his intention for me to receive sole ownership of the lake house upon his death. He describes his reasoning in detail. He also, on page 3, notes his concern about his mother's approach to family assets and his reasons for structuring the transfer as he did. Mr. Albright was reading the document, his associate peering over his shoulder. The courtroom was profoundly quiet. That's a forgery. Beatrice's voice shattered the silence like a stone through glass. She lunged, not a controlled movement, not even a calculated angry one, but something raw and less restrained than anything I'd witnessed from her in 9 years. Her hands reached for the documents in front of me, but her fingernails caught my cheek instead. A thin, bright line of pain. Order. Judge Davies' gavel came down with the finality of a period at the end of a sentence. One more outburst, Mrs. Sterling, and I will have you removed from this courtroom and held in contempt. I touched my cheek, looking at the faint red on my fingertip. The gallery was absolutely silent. Mr. Albright looked at Beatrice. He looked at me. He looked at the document in his hands. Your Honor, he said carefully, the plaintiff requests a brief recess to review. The proceeding will continue, Judge Davies stated. You had full discovery, Counselor. Continue, Mrs. Vance. I reached back into my folder. You're right about one thing, Beatrice, I said, though I wasn't looking at Mr. Albright. I was looking directly at her, because what was about to happen was for her, not for her attorneys. Her attorneys were professionals doing a job. Beatrice was a mother who had spent 9 years treating her son's death as a financial transaction and had come to a courthouse today expecting to complete it. She deserved to hear what Arthur had to say. I did bar you from the house in his final months, I admitted, but it wasn't my decision. I placed the small digital recorder on the defense table. I brought Arthur's audio to explain whose decision it was. I pressed play. First, heavy breathing. The kind of breathing belonging to a man expending a significant portion of his available energy simply to remain upright, simply to speak. Arthur's breathing in those last months had a quality I'd learned to discern, like listening for changes in the weather. The slight shift in depth that meant he was tiring, the shallowness that indicated pain was controlling him rather than the other way around. Chloe made a soft, involuntary sound in the gallery, the sound of a daughter hearing her father's breath for the first time since he'd stopped breathing. Then, Beatrice's voice, amplified in a courtroom with excellent acoustics by a recorder Arthur had held close to his phone, positioned with the specific intent of capturing every word. Beatrice Sterling's voice was clear, complete, and precisely as she had sounded on a Thursday afternoon, 9 months before Arthur died, when she had called him for the 4th time in a week to discuss the lake house, the Sterling family trust, and the documents she wanted him to sign. "You sign those papers today, or I swear to God I will come over there and make her life a living hell. I will make what's left of your marriage a nightmare. You sign them, or I, then Arthur." Weak, exhausted. The voice of a man spending something he had very little left of, because it mattered enough. "Mom, stop. Please stop." A pause. "You only care about the money. You've always only cared about the money. I know that now. And I'm sorry it took me this long." Another pause, longer this time. "If you don't leave Eleanor alone, if you don't stop this, I don't want you at the house anymore. I don't want to see you again before I die. I want to die in peace. Please, just let me die in peace." The recording clicked off. The courtroom remained absolutely still. Not Mr. Albright, not his associates, not the gallery, not the bailiff. Nobody reached for water or shifted in their seat or made the small adjustments people make when they are present in a room but not entirely absorbed by it. Everyone was utterly absorbed. Beatrice Sterling sat at the plaintiff's table, her face buried in her hands. The Armani suit, which had conveyed authority when she entered an theater in the hallway, now looked like what it was, expensive fabric on a woman who had just heard her son tell her he didn't want to see her before he died. I didn't feel triumphant. I want to be honest about that, because this is an honest account. I felt the completion of something, the specific, quiet satisfaction of a process reaching its correct conclusion. But somewhere beneath that, I also felt a profound sense of grief for the waste of it all. 9 years of dinners and holidays, the sustained, exhausting effort of a woman who needed to be managed rather than known. 11 months of a dying man using energy he couldn't spare to protect his wife from his own mother. The sheer waste of it. The specific sadness of a family that could have been something else. Judge Davies' gavel came down hard, final, the sound of an institution delivering its verdict. Case dismissed with prejudice. His voice was that of a judge who makes many rulings and means every single one. Plaintiff is ordered to pay all defense legal fees and court costs. Mrs. Sterling, he looked directly at Beatrice with the measured attention of someone who wants their words to land precisely. "If I ever see you in my courtroom again, I will hold you in contempt before you've even had time to sit down." He then looked at me. Something in his expression, not warmth, exactly, not sentimentality, but recognition, registered briefly before returning to the professional composure of a judge in session. "Thank you for your service, Colonel," he said, acknowledging both my military career and my conduct in this proceeding. He left the bench. Chloe's arms were around my neck before I had fully risen from my chair. She was weeping, with the full, unguarded release of someone who has been afraid for a long time and is now suddenly and completely safe. I held her and felt the weight of the last 11 months, the way you feel weight when it's finally set down, not its absence, but the specific awareness of what it had been. Mr. Albright was gathering his papers without looking at me, which I respected because it was the professional thing to do, and because dignity in defeat is underrated. His associates packed quietly, with the subdued efficiency of people who had just significantly revised their understanding of a situation. Beatrice hadn't moved. She was still at the table, hands now resting in her lap, her practiced composure entirely gone. What remained was something older and more honest than composure, a 68-year-old woman sitting in a courtroom where she had just lost in every direction at once, including the direction that mattered most, which was not the lake house. I paused beside the table on my way out. I looked at her. She looked up at me. I wanted to say something measured and final, the kind of line that tidily concludes a story. I didn't. I looked at her for a moment, at the woman Arthur had loved in the complicated, exhausted, beautiful way of a son who had never stopped trying. And I said nothing. There was nothing to say that Arthur hadn't already said. I walked out. The legal fees Beatrice was ordered to pay totaled $34,800, which covered the consultation fees with a specific attorney, the filing costs, the certified document preparation, and the court reporter's transcript. I donated $30,000 of it to the Pancreatic Cancer Action Network in Arthur's name. The lake house is mine. It was always mine, legally, morally, and in every way Arthur intended when he sat at his desk 8 months before his death and wrote a letter of intent in his own hand, having it notarized by Martha Glenn, who had been the town's notary for 22 years. Martha testified in a subsequent deposition that Arthur Vance had been entirely lucid, entirely intentional, and had asked her to read the document back to him twice before he signed it. She did. He signed it. She stamped it. Martha Glenn, 22 years as a notary. He knew exactly what he was doing. Arthur's oncologist, Dr. Alan Kincaid, 17 years in oncology, board certified, who had managed Arthur's care for the entirety of his illness, provided a written statement confirming that 8 months prior to the deed transfer, Arthur's cognitive function was unimpaired, his decision-making capacity intact, and his medication at that point entirely non-narcotic. Arthur knew exactly what he was doing. He always knew exactly what he was doing.